The President, please be seated. The court is now back in session. We would like to hand over to counsel for Mr. Nguyen Chia to continue putting questions for this witness. And then counsel for Mr. Khieu Samphan will have the floor. You may proceed.
Thank you, Mr. President. I only have very few questions to the witness. Mr. Witness, before the break, you have testified that you never met Nguyen Chia in person. Have you ever heard him speak in a meeting?
Response. No, I haven't. I haven't received any instructions, either directly or indirectly.
I understand, but maybe you've heard him speaking on, for instance, political education sessions where lots of other cadres or commanders were present.
Response. No, I have never heard him speak during political sessions, but I heard from my superior about what he speaks or spoke in the meetings.
And do you remember what that was?
Response. It was in 1976, 77 and 78 when the Khmer soldiers were still engaging in fighting with the Vietnamese troops.
But my question to you, Mr. Witness, was what your colleague told you that he had heard Nguyen Chia say during this political education meeting.
Response. My subordinates would not hear anything about this. I myself did not hear Nguyen Chia speak in meetings personally, let alone my subordinates.
Last question, Mr. Witness. Could you tell the chamber what you did after January 1979?
Response. After 1979, I remained a soldier.
Until when did you remain a soldier?
Response. Until these days.
Just to be clear, did you stay a Khmer Rouge soldier after 79, or did you become part of the government forces after 79?
Response. I had been the Khmer Rouge soldier all along until the day when the win-win policy employed by the government of Cambodia and the Khmer Rouge troops then reintegrated into the government, and I am still holding the same position.
Thank you very much, Mr. Witness. Thank you, Mr. President.
The President, thank you, Counsel. Next, we would like to hand over to counsels for Mr. Kilsampon, please. Counsel Kung Samon. Thank you, Mr. President. Good afternoon, Mr. President, Your Honors. Good afternoon, Mr. Witness. I have a few questions for you. Before that, allow me to introduce myself. I am Kung Samon, co-counsel for Mr. Kilsampon. My first question is about your biography. I would like you to clarify your status during the resistance period and during the Democratic Cambodia. I noted your document E3/419. And the question number 1, you stated about how you rose through ranks. Allow me to read this to you, but please let me know if you have obtained the document. If you have, then you can verify, check against the reading that I will be doing now. Question. Please describe your background prior to the 17th of April 1975. I may skip this page number 2 and move to page number 3 instead, but it is relevant to question number 1. Now I will be citing. I was in the district military forces until the 28th of July 1971. I was a combatant at the provincial military level under the supervision of Saum, deceased, the Sector 13 Committee. My company commander was Sien, deceased. On the 23rd of March 1972, I became the commander of a platoon of Company 14, still under the supervision of Sien. My platoon was a special unit under the supervision of Sector 13. In December 1974, I was chairman of Battalion 204, subordinate to Brigade 2, stationed in the southwest zone. During October 1926, I became chairman of Regiment 12, still subordinate to Brigade 2. My first question to you is, you said you was a combatant at the provincial military level. Was provincial military level part of the military structure used in those days? Response. I believe that the investigators may have mistyped this. I said that after 1971, I was a soldier, and then I worked as a soldier at the district level, then provincial level, and I was at the platoon already, and I think combatant would not be my correct title because I had my role to play as a commander of a platoon back then. Question. Thank you. Can you also clarify When you became the commander of that platoon at the provincial military level? Response: it was in 1972. Question: thank you.
ចឹងនៅឆ្នាំ72នេះបើគិតពីធរវេលាដែលលោកបានបម្រើការជាយោធាលោកអាចបញ្ជាក់បានទេថាបានប្រមាណឆ្នាំ
How long had you been serving in the military by 1972 when you became the commander of the platoon? Response: I had been in the military for over 2 years. Question: thank you. I may go back a little bit, and I would like to ask you a question before you rose to become the commander of the platoon. Where did you work before you worked at the provincial military unit? Response: first, I worked as the militia at Ong Ta Saom. A short while later, I worked at the provincial, rather district military level of Tram Kok. Question: thank you. In the District 105 military structure, what did you do? What was your role? Response: I was the head of the group, or rather the squad, but people did not write it in detail. So when I worked at the provincial military level, then I became the platoon commander. Question: thank you. You said that in 1974 you rose to become the head of Battalion 203. Is the date correct? Response: yes, it is. Question: thank you. Regarding your promotion, can you tell the chamber how you could rise through the senior ranks by stepping or skipping a few ranks in between? Response: I believe that one of the phrase was missing. I said that I worked at the provincial military level as the battalion, but before I became the commander of the battalion, I was the commander of a company already. Question: is it fair to say that you rose through proper hierarchy without skipping any ranks? But that message was not clearly emphasized in this document. Response: I believe that is the case. The document here does not cover my full story because I rose through ranks step by step. Because at the beginning I was the head of a squad of 12 people, then the commander of a platoon, then commander of company, battalion, regiment, so on and so forth, in this hierarchical order. Question: thank you. I would like to now ask you a question concerning your family background prior to 1975. What class did you belong to before the Democratic Cambodia regime? Response. I belong to the lower middle class peasant at Ong Tasaum in Takao province. I went to high school at Samdak O High School at Ong Tasaum. Question. Thank you. Did your class status have anything to do with your rising through different ranks until you were promoted to the regimental level, Commander? Response. Rising through ranks, hierarchical ranks, was done quickly as well, because I was a brave person, I had good moral, and I served the people very well. So these three criteria served me well for quick promotion through ranks. Question. Thank you. Did this have to do with your class, your status as the lower middle class peasant class? Response. I think it had something to do with this as well, because before a person was selected to become a commander, he or she must belong to a lower middle class peasant or poor peasant. Question. Thank you. What else made you rise through these ranks? Response. I think I have some special quality, and I still remember this very well. I am very brave. Question. Thank you. On the same document, question and answer number 5. I would like to read paragraph number 3 as follows. I think you were asked this question first. Document ERN 009194462 states that the Southwest Zone military forces participated in operations to sweep clean cadres in the East Zone between 1977 and 1978. Please clearly clarify these events according to your knowledge. And that's the question. And here, what you had to respond. In the meetings, Tamok talked about sending the forces to the east to counter the Vietnamese troop that was invading Cambodia, and also the meeting was to prepare additional forces to be inserted to fill out the former forces that had been previously been pulled out and sent to the East Zone. I did not know I did not know about that previous plan to pull out forces because I did not attend the meeting. My question to you is, You said there was a meeting in 1977 about the attack or invasion of the Vietnamese troops into Cambodia. How can you tell the chamber the scale of the attack that occurred at that time? Response. By late 1977 and in particular early 1978, a large-scale attack was launched by the Vietnamese troops. And in Svay Rieng province, Vietnamese troops would be attacking Cambodia at all fronts. So when I was there with our troops, we already were received by the Vietnamese troops that had preoccupied this vicinity in Chantria district and other neighboring districts of Svay Rieng. So the attack was of large scale. And you asked me about the meeting at Thamok House. Indeed, the main objective for that meeting was to counter the invading Vietnamese troops at these locations. Question. Thank you. Can you also clarify or tell the chamber how long had the Vietnamese troops been in Cambodia, attacking Cambodia at that time? Response. When I was there, Vietnamese troops had, as I told you, preoccupied this whole border area of Svay Rieng, and I was wounded in the attack, and I had I was engaged in the fighting, and I had to be admitted to the hospital where I remained treated for 3 months. After I was discharged from the hospital, I learned already that the Vietnamese troops came deeper inside Cambodia, and our troops would retreat because we were outnumbered by the Vietnamese troops. And some of our troops were arrested by the Vietnamese. So there were 5 divisions of Khmer Rouge soldiers who were deployed to counter the Vietnamese troops, but almost all the divisions vanished after all. And we retreated to National Road number 5. Question, you mentioned about National Road number 5. Where are you talking about here? Which part of the country you're referring to? Response. At that time, the Vietnamese launched a very large-scale attack, and they moved all the way to Phnom Penh. That's why our troops had to retreat. Question. From 1977 until the time when the Vietnamese troops attacked Phnom Penh, when was it when the Vietnamese troops attacked Phnom Penh, and where were you? Response. It was in 1978 that attacks had already been carried out, and by late 1978 they reached the area of road number 5. Question. So by late 1977 and early 1978, the Khmer Rouge soldiers were retreating and they would not counter the Vietnamese troops. Is that correct? Response. That is correct.
បាទសូមអរគុណលោក
Question. Thank you.
ពិនិត្យមកចម្លើយទី6
May I now refer to question and answer number 6 in your statement? I would like to read the question first.
បាននិយាយអំពីការ
Question. Witnesses have spoken about the sweeping clean of the East Zone cadres around late 1977. In your position as commander of Regiment 12 of the Southwest Zone, why were you not assigned to participate in those sweeping clean operations? And you said, I would cite your statement, in 1977, at the Cambodian-Vietnamese border in Takao province and in Kampot province, there were disputes with Vietnam. Therefore, my troops were stationed on the Southwest Zone battlefield at Prek Chik Vinh Tê. They were in Takao province. At that time, I was wounded in left hand during combat with Vietnamese troops at Prek Chik Vinh Tê. My question to you,
សមរភូមិនៅខេត្តកំពតនិងខេត្តតាកែវថាមានព្រំព្រៀងដូចម្តេចដែរនៅពេលនោះ
how large was the battlefield or the fighting in Kampot battle zone?
ខ្ញុំសូមបញ្ជាក់ថា
Response.
77នេះនៅខេត្តតាកែវ
In 1977, in Takao and Kampot provinces, fierce fightings occurred. And by mid-1977, Vietnamese troops already invaded all the way to the vicinity of border of Takao province. But the Khmer Rouge soldiers had to counter back, and there was a tug of war. And we could drive them back all the way to the Vietnamese and Cambodian border, but they came back, so it was a back and forth fighting. It's like tug of war. Question. When was this tug of war happening? Did it happen from late 1977 or from when?
Answer. The attack back and forth sometimes took places for 1 month or 2 months. So we drove them back and then they pushed us back. And the situation was similar to that occurred in Svai Rieng.
បាទសូមអរគុណ
Thank you.
ខ្ញុំសូមបន្តទៅឯកសារដដែលហ្នឹងខ្ញុំ
In the same document, in question answer session number 10,
គេសួរលោក
you were asked the following question. Please describe in detail the supervisory and leadership structure of Sector 13, Tramkot District, Takai Province. And in your answer, you stated Saum, deceased, was Sector 13 Secretary, Tramkot District.
ថាស្រុក 105
And Tramkot District was called District 105 and District Committee was Nhieu.
ថាសោមនិង
I do not know where Saum and Nhieu came from. I just know that they had been members of the resistance during the pre-1970 era.
ខ្ញុំមិនដឹងច្បាស់លាស់អំពី
I do not know clearly the civilian leadership structure
នៅខាងយោធា
because I was in the military.
ជាទូទៅឋានានុក្រម
In general, in the hierarchy at that time, sector level was appointed by the zone and district level was appointed by the sector.
ខ្ញុំសូមបញ្ចប់ការដកស្រង់ត្រឹមប៉ុណ្ណេះខ្ញុំមានសំណួរបន្ថែមទាក់ទង
I have additional questions through this
ចំពោះ
section of your interview.
កថាខណ្ឌចុងក្រោយដែលលោកបញ្ជាក់ថា
For the last sentence
ថ្នាក់តំបន់
that you said,
តែងតាំងដោយភូមិភាគហើយ
sector level was appointed by the zone and the district level was appointed by the sector.
ពីការអនុវត្តជាក់ស្ដែងនៅ
In practice, did you know about
ឬមួយក៏លោកដឹង
this implementation?
វត្តនៅទីទាំងប្រទេសនេះ
In particular in your area, or you think or you knew that this kind of implementation was countrywide?
ខ្ញុំសូមបញ្ជាក់ថា
Answer.
ពេលនោះបើនិយាយពីអាយុដែលខ្ញុំធ្វើទាហានក៏នៅខ្ចីដែរ
At that time, my
ក៏នៅមានកម្រិតដែរ
time with the military was not that long. I only heard people talking to one another
ស្រុកគឺថ្វាយខេត្តគឺចាត់តាំង
that
តំបន់នេះគឺ
the
ស្រុក
district governor was appointed by the provincial governor,
រូបមន្តខេត្ត
so on and so forth. And of course, I did not know whether it was a common practice nationwide.
បាទសូមអរគុណ
Thank you.
ខ្ញុំមានចំណុចចុងក្រោយចង់សួរលោក
My last question for you is related to Khieu Samphan.
ឈ្មោះលោកខៀវសំផនទេមុនឆ្នាំ
Did you ever know or hear of Khieu Samphan before 1970?
ខ្ញុំធ្លាប់
Answer.
ខៀវសំផន
I heard of Khieu Samphan's name when I was still at school.
ធ្វើសុភា
That time he was a
យ៉ាងណានោះទេ
member of the parliament, but I never knew how he looked like.
លោកអាចបញ្ជាក់បានទេថាលោកឮយ៉ាង
Thank you. Question. What did you hear about him? Answer.
ឮថាគាត់ជាតំណាងរាស្ត្រ
I heard that he was a member of the parliament and that he possessed only a very old bicycle. That's all. I did not know anything in details about him. Thank you.
ចុះក្រោយ
Question.
ឆ្នាំ
And after 1970
1975
until 1975, that is the 17th April 1975,
ឬក៏បានដឹង
did you hear
សំផនយ៉ាងម៉េចដែរ
or know
ការងាររបស់លោក
more about Khieu Samphan and his role?
ចំណុចនេះខ្ញុំសូមបញ្ជាក់
Answer.
ខ្ញុំបានគ្រាន់តែឮទេ
I would like to say that I only heard about it.
តគ្នាហើយថាលោកខៀវសំផនជាប្រធាន
I heard through other people that he was the president of the state presidium, but I never met him.
បើនិយាយពីពេលហ្នឹងឋានៈវាទាបហើយដល់ទៅ
As I said, I was at a lower level, so I could not grasp the situation of the upper leadership.
ពី70ដល់ឆ្នាំ
Question. My question to you is for the period between 1970 and 1975. And of course, I will ask you for the period after 1975. Can you clarify that?
ខ្ញុំអាចបែងចែកពេល
Answer. Yes.
ឆ្នាំ70មក75
For the period between 1970 to 1975, I only heard of his name. I never met him.
បាទសូមអរគុណ
Thank you. Question. What about during the Democratic Cambodia regime? What did you hear about Khieu Samphan?
ខ្ញុំសូមបញ្ជាក់ថាសម័យ
Answer. During the period of Democratic Cambodia,
ឮតាមការប្រជុំរបស់
I heard through the meetings with of the senior leaderships that Khieu Samphan was the president of the state presidium, but I never had any contact with him.
បាទសូមអរគុណដល់លោក
Thank you.
បទពិសោធន៍
Question.
ការទទួលការបញ្ជា
Did you ever experience receiving any orders or written orders or a telegram from Khieu Samphan to your supervisor and then from your supervisor to you
ជាការបញ្ជាចេញពីលោកខៀវសំផនដែរទេ
that you were told by your supervisor that the order or the instruction came from Khieu Samphan?
ខ្ញុំសូមបញ្ជាក់បញ្ហានេះឲ្យច្បាស់
Answer. I'd like to clarify this issue.
តាក់ទងនឹង
For Mr. Khieu Samphan, when it comes to military matters or military training,
មិនដែលទទួលសោះ
we never received anything from him.
បាទសូមអរគុណលោកអ៊ឹងផាន
Thank you, Mr. Ieng Pan. Mr. President, I have no further questions for this witness. President, thank you. The proceeding of hearing the testimony of the witness Ieng Pan has now concluded. It finished a little bit early than they expected, so then we can have more time to hear the request by the lead co-lawyers. We'd like to ask the Defense Counsel for Nuon Chea whether your client would like to participate in the hearing of the request by the lead co-lawyers.
No, Mr. President, he would prefer to go back to his cell.
President, thank you. And what about Kissampon's defense team? Does your client prefer to remain here to hear the request by the lead co-lawyers?
No, Mr. President, it's the same for Mr. Kissampa, who wishes to return to his temporary cell if possible.
President, thank you. Mr. Ieng Pan, the hearing of your testimony has now concluded and you're excused. And we would like to thank you very much for your valuable time to come to testify before this court with patience and best effort. Your testimony may contribute to ascertaining the truth in this case, and we wish you all the best and bon voyage. And you may return to your residence. As for the Duty Counsel, you may excuse yourself. Court officer, in collaboration with Visu, please assist Mr. Ieng Pan to return to wherever he wishes to go to or to his residence. And security guards are instructed to take Nuon Chea and Kissampon back to the detention facility and have them returned tomorrow morning to the courtroom prior to 9 a.m. As for Nuon Chea, bring him to the holding cell downstairs, which is equipped with the audio and visual equipment for him to follow the proceeding. Mr. Ieng Pan and the Duty Counsel, you are now excused. President, we will now proceed with the hearing of the request by the lead co-lawyers. Regarding certain matters. And in order to clarify the request, and before I hand the floor to the lead co-lawyers for their requests and reasons, I would like to hand the floor to Judge Cartwright to clarify on one request concerning the request made through the senior legal officers of the trial chamber. Judge Cartwright, please proceed.
Thank you, President. As the President has indicated, the oral submissions relate only to the issue of whether other parties have the right to question civil parties following their statements. There is an additional matter which the trial chamber wishes to clarify and to correct. The parties have been advised that the civil parties who wished to call expert TCE 12 are entitled to call him on the 5th of June, that leaves a gap on Monday, the 27th of May, where he was originally scheduled to be heard. The trial chamber does not wish the lead co-lawyers to insert reserve civil parties into that Monday. It would much prefer that the civil parties ensure that their primary selection of civil parties are heard first, starting on Monday morning, the 27th of May. And should there be time later in the week, during the 4 days that you have for civil parties, then you may call reserve civil parties. The trial chamber does not wish to be faced with the prospect of not getting through your primary civil parties because the first half day has been taken up with your reserve civil parties. So we ask that you reorganise to ensure that your primary civil parties, your first choice, are called starting on Monday morning, the 27th of May. You have 4 days only, that is Monday through Thursday of next week, and you have, by reason of the unavailability of the expert, been granted an extension of half a day to accommodate the expert on Monday, the 5th of June. I hope that the lead co-lawyers understand what the trial chamber has just ruled. Are there any questions concerning that?
Yes, thank you, Judge Cartwright. There's simply one problem, is that the civil parties that we have proposed for the 4th of June will only be available on that day. So those, of course, who are set for June 4th cannot be heard before, which means that, hypothetically speaking, the expert's time on 27 May can not be compensated by a postponement of the civil parties that we had scheduled originally. So I hope I'll try to be clear here. And I understand that the expert is scheduled for the morning of the 27th, not for the whole day. So we have indeed civil parties available for the 27th, the 29th, and the 30th. And we have 4 who can only come on the 4th of June. So if the chamber does not wish that we use time that was originally scheduled for the expert on the 27th on the morning, this cannot be done by postponing all of the civil parties. That's all I wanted to say.
There seems to be confusion over dates. You tell us that the expert is available only on the 5th of June, and you have 4 days beginning from the 27th of May. So where does the 4th of June enter into this discussion?
We have 4 days that are the 27th, the 29th, 30th, and the 4th of June. Because of the holidays, there will be no hearing on the 28th and on the 3rd. So we have 4 days, and indeed we had scheduled a half day for the expert at the beginning of these 4 days. If the chamber does not wish to give us 4.5 days, well, then we will lose the morning of the 27th, and we will take the morning of the 5th of June. The rest, and it will still be 4 days for the other parties, but if the chamber gives us 4.5 days, then we can have the reserve civil parties during the first days, the 27th and the 29th. But we cannot postpone all of the civil parties. We have indeed scheduled for the expert and the civil parties for 4 days, but because of the holidays, it will have to be spread out this way.
President, National Lead Collegiate, you may proceed. Mr. President, Your Honors, I understand the concern of the judges of the bench that you prefer to hear the testimonies of the civil parties based on the primary list that we submitted to Your Honors in the first list of the priority civil parties. And in fact, we are delighted to have a separate time for the expert or additional time for other civil parties whose names appear on the list. In addition to the priority list of the civil parties, as indicated by my international counterpart, there are 3 civil parties whose schedule cannot be changed from the 4th of June. As for other civil parties, their schedule can be shifted or moved to the 27th, and also to include the names of the civil party from the reserve list, or to move them forward. And we try to do this so that Your Honors can hear the testimonies of the primary civil parties before the other reserved civil parties on the reserve list. In the cases that the hearing of the testimonies time may change, we try our best to accommodate the time allocation for the civil parties, and if the civil party speaks more than the allocated time, it should be to a minimum level, so that opportunity can be given to other civil parties to express themselves as much as possible. Thank you. Judge Cartwright, please take the floor. Thank you.
Thank you, President. The Chamber will allow the 4 days for civil parties, 27, 29 and 30 May, and 4 June, and the civil parties can be allocated as the lead co-lawyers choose. An additional half day will be allocated on the 5th of June for the expert. The civil party lead co-lawyers need to be clear that no extensions will be granted, and that should the Chamber decide to, after hearing submissions, to allow the other parties the opportunity to question the civil parties, you will simply have to readjust your schedule of civil parties. Is that clear now? You look as if you didn't understand me. You get 4 days for the civil parties. You get half a day for the expert, regardless of whether the trial chamber decides after hearing submissions to allow the parties to question the civil parties. That is the total time allocated. No more time will be granted. Is that understood now?
Yes, we have understood perfectly well, and thank you very much for this extra half day. Now, regarding the questioning, we had indeed calculated the civil party time depending on the examination, so I don't think there will be a problem. Thank you.
President, thank you. We would like now to give the floor to the lead co-lawyers to make their oral submission. As far as the reasons to support your submission, you may proceed. Once again, good afternoon, Your Honors. In our email communication that was sent by the legal officer Roger Philip, there are 2 issues that were highlighted in that email. The first issue is related to the fact that the lead co-lawyers made a request to the trial chamber whether the prosecution and the counsels for the accused will be given the floor to put questions to the civil parties who will be testified regarding the harms done. And the second point is that the lead co-lawyers for civil parties would like the trial chamber to hear the statement of harm or damages by the civil parties, and that they should leave the courtroom before other parties are allowed to make comments to the harms or damages expressed by the civil parties. To respond to the first point, we wish not to make any longer comments, and maybe my colleague, Ms. Simino Ford, might shed light on that. However, I am of the view that it is up to the court to decide whether other parties will be allowed to question the civil parties. And Ms. Elizabeth will add further comments to the first point. As for the second point raised in the email regarding the statement of harm, my oral submission is that that will be the opportunity accorded to the civil parties to raise the issues of their harm, and not only in the case of 002/01, but they should also raise of what they lost under the entire Khmer Rouge regime. that would be the time that they should be allowed to speak out about the loss or harm they received or suffered under the Khmer Rouge regime, so that everybody, including the United Nations, could hear of their statements and try to prevent such crimes from happening in the future. As for the harms suffered by the civil parties, the statement of harm would be the opportunity for them to declare about their loss, in particular in case 002/01, which is also an opportunity for them to make a support of their application and their request for reparation and the severity of the crimes committed. And another point that I'd like to raise, Your Honours, coming out from the statement of harm is for the purpose of national reconciliation. When the civil party is allowed to make such a statement, it would help them relieve their psychological suffering. And this is also the purpose that this court is trying to find justice for those civil parties. At the same time, when they made a statement of harm and the statement about their losses, we in fact made our previous request to the chamber that before a party can make a comment on what will be stated by a civil party concerning the harm, the civil party shall be excused from the courtroom so that they cannot hear comments made by civil parties, as those comments may affect their psychological status, and that does not help in any way the feeling of the civil parties, and that might have an adverse effect on the psychological state of that civil party. Of course, the accused or the defense counsel may make observation of the statement by the civil parties. President interrupts. Lead co-lawyer for civil parties, you should make your brief request and the reasons briefly to the point, as you only have 10 minutes to make your request, and then other parties will be given the time to make comments to your request. So you have to state clearly of your request, what your requests are, and why, or the reasons for those requests. You need to make those reasons for the request so that other parties can hear of the grounds and that they may either support or object to your reasons for the request. And your 10-minute time allocation is almost gone. And of course, then you would need time for your international counterpart. And if you keep repeating and raising the same issue again and again, it's a waste of time.
Counsel Pekong, thank you, Mr. President. I may need only 1 more minute, please. And to be brief, in order not to do things that affect the civil parties, may we humbly ask that any psychological impact that may have caused from the parties during the proceeding should be avoided, and that civil parties should be brought away from this courtroom before such impact be made. My humble request is just to make sure civil party would not suffer more psychological harm unnecessarily. Thank you, Mr. President.
Merci, Monsieur le Président. Thank you, President. I will endeavor to reply very briefly to the email that we received this afternoon in response to the proposal that we have forwarded. I believe that a distinction must be made between the previous hearings when civil parties were being heard on the facts and were being examined by the parties on the facts alleged, following which the civil parties were enabled to make statements on their suffering and victims' impact. Parties were enabled to make comments once those civil parties had left the hearings. We must make a distinction with the civil parties to be heard as of next week. Next week and the following week, the civil parties who are going to be heard will speak about their suffering and victims' impact as required by your honorable chamber. It is very clear for the civil party lead lawyers that questions the right of questioning must be given to the co-prosecutors and the parties. We intend to hear some 4 civil parties per day, and we have estimated some 30 to 40 minutes, 45 minutes to be allocated for the civil party lawyer during cross-examination. This is important for the trial chamber to know because I believe that there's some misunderstandings between those 2 sets of civil parties. When a party is allocated time for questioning, it is not necessary for the defense teams to avail themselves of a time for commenting. This is inappropriate and not justified in this particular case. They will be accorded normal questioning time. What we suggest is very straightforward. It is that each civil party be heard, that the civil party lawyer ask the civil party questions, and that time for examinations be given to the co-prosecutors and the other defense parties to the scale of 30 minutes respectively. We believe that we must respect those confines. There is no need to calculate additional time since the civil parties are going to be questioned on victims' impact by all parties, and there will be no need for further questioning. This, Your Honors, is the official position of the civil party lead lawyers today. Thank you.
The President, thank you, Counsel. International co-prosecutors, would you wish to say anything on this? You may proceed.
Mr. President, thank you very much. I have 10 submissions or observations that the prosecution wish to make. The first is that the prosecution's position is that we submit that civil parties should be questioned on all issues of relevance to the case. The second submission is this, that the civil parties that we will now hear from are actual victims and they give direct evidence about their suffering. It is our submission that it is inevitable when a civil party comes to court and starts talking about their suffering, there will be reference to individual crime sites. We submit that these 2 pieces of evidence, the suffering on the one hand and the crime site on the other, are inextricably linked and cannot be separated. If I can give the example of a civil party coming into court and saying words to this effect: "My suffering arises from the following crimes at the following locations," and thereby gives direct evidence going to relevant issues in the case. My third submission is this, that to the extent that the trial chamber may be proposing to model its approach on the approach adopted in Case 1 in the Duik trial, it is our submission that that was a very different scenario. Most of the civil parties in the Duik trial were relatives of the victims and could not therefore give direct evidence of crimes. Our fourth submission is this, that civil parties proposing to testify will in many cases themselves be victims of the forced movements. In other words, it is inevitable, we submit, that they will give evidence going to the heart of this important trial issue. Fifthly, it is the prosecution's submission that if the trial chamber entertains either the prosecution or the defence simply being able to make comments on suffering, that would not conform with existing practice. The sixth submission is this, and this is a fair trial matter we wish to raise in the context of the defence. If during the testimony of a civil party, that civil party, whilst being spoken to about suffering, provides probative and relevant evidence going to issues in the case, it is only fair that the defence should be able to challenge such evidence. And if that is so, equality would demand equal rights for the prosecution and the defence. The seventh submission is that I hope I read accurately in an email this morning that the trial chamber was proposing that civil parties would be asked to provide a list of questions to be asked of the accused. We submit that it is inevitable that those questions will contain relevant admissible evidence upon which the parties should be given full rights of examination. The eighth submission is that the trial chamber had already decided that parties should question civil parties, and time allocations have been made, and I anticipate that both the prosecution and the defence had been proceeding on the basis that full examination would take place. The ninth submission relates to the duty of the court to ascertain the truth, and that being the mandate of the court, we would urge the court to treat these civil party witnesses in the same way as previous civil party witnesses. The 10th and final submission is that the prosecutors wish to give the trial chamber the assurance that civil party witnesses will be dealt with sensitively, and that the prosecution would only seek to ask questions going to broader issues if the need really arises. Thank you.
The President, thank you. Counsels for the accused, would you wish to also make any observation regarding this request, starting from counsels for Mr. Nunji first?
Thank you, Mr. President. I don't think I would ever be saying this in a court of law, but I think I agree with all 10 submissions from the prosecution. And the 10th submission would be a mutatis mutandis situation. Of course, we will also approach these civil parties sensitively. So we fully concur with the submissions of the prosecution.
The President, thank you, Counsel. Counsel for Mr. Kilsampon, you may now proceed.
Thank you, Mr. President. I am shocked by the principle that consists in having people come who rightfully or wrongfully present themselves as victims without them being questioned on facts beforehand. Bringing people here for them to speak only about their harm suffered without them explaining the reasons and the experience that led to this harm seems unusual to me and incongruous in such a trial. Maybe it corresponds to the image that certain people might have of reconciliation, national reconciliation, but I believe I feel that this necessity of reconciliation for Cambodia with itself is not that important in relation to the trial itself. So for me, people who only speak about their harm does not correspond, in my eyes, to the definition of what a trial should be. So these people are going to come and they will speak about the harm they suffered, fine, okay. And we know that it's difficult to distinguish the origin, the factual aspect of this harm from the harm itself, because this week and on Thursday we're going to be hearing a witness who will speak to us again, because when he expressed himself on the harm he suffered, well, he brought up new facts. So, in the end, the proper conduct of next week's hearing is in the hands of my civil party colleagues following these issues of principle that I spoke about. It seems to me that it is normal if these people come next week, that aspects linked to harm slide to something that is supposedly factual. Well, we will manage as we can, faced with this situation, in order to try to examine them and to see on what the harm they describe really rests on. I believe that this is the least worth solution, but since we don't have anything else to deal with, I don't have that much more to add right now.
The President, thank you. Now, legal lawyer for the civil parties, you may now proceed.
In response to what my honourable friend has just said, I also share the co-prosecutor's concerns. I simply do have one observation. This hearing may appear rather astonishing for those from a civil law background, and to have the civil parties talk about impact. If there has been expansion of discussion on the facts in the indictment, then we would have to allocate up to 1 day for each civil party. If we're going to address the totality of facts, we are obviously going to have to set aside much more time than the 4 days for the civil parties to talk about victims' impact exclusively. Those are my comments.
Mr. President, the Chamber has heard requests made by lead co-lawyers for the civil party, and at the same time, we have also heard observations made by parties to the proceedings regarding the request. The request regarding the expression of statement of harms by civil parties during the proceedings, and also the observations that other parties may have regarding the statement of harm. The Chamber is grateful indeed to all the observations made and submissions made, and the Chamber will rule upon this in due course. And the Chamber will make sure that parties are well informed of our decision in due course so that they are prepared for the following week hearings. For today's session, the Chamber will adjourn the session, and the next session will be resumed on Tuesday at 9 a.m. For tomorrow's sessions and after tomorrow's sessions, the Chamber will be hearing testimony of two types of witnesses. First, we will hear witness TCW 548 proposed by co-prosecutors and counsels for Mr. Kyew Sampon. We will hear this witness for the whole day, half morning of 21st and half morning of 22nd. And we also will be hearing TCW 277 in the afternoon of 22nd. The Chamber will be hearing TCCP 89 through video conference from France. Counsels for Mr. Kyew Sampon will be allocated the time to put questions to these two witnesses through video conference before the other parties. The court is adjourned.
សូមគោរព